So, good morning, everyone. Welcome to our virtual class. This is for BAM 6201, Law on Obligations and Contracts. So, once more, I am Professor Maria Romana Daguio, your assigned online learning coordinator for this course. And today, class, we are going to continue our discussion with the extinguishment of obligation. So, we are now in section 2, 3, 4, and 5. So before I move on, no, let me give you a recap of what we have learned last week. So we learned that an obligation class can be extinguished through payment or performance. So that is section 1. So today, no, we are going to proceed with section 2. All right, so let's move on. So under section 2, loss of the thing due, we have Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So pag nawala yung bagay na i-deliver class, no? Ang pinag-uusapan nating bagay dito is specific, determinate. Okay? So kung sasakyan halimbawa yung i-deliver, specific ang plate number, chassis number, no? So hindi generic. So determinate thing. So pag nawala yung determinate thing na yun class, no? At hindi kasalanan ni debtor, maaaring dahil halimbawa sa um, fortuitous event, no? And kung hindi pa naman talaga nakatakdang i-deliver yon bago mawala. So walang magiging pananagutan doon si debtor. So hindi siya liable for that and the obligation is now extinguished. But on the other hand, class, when by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation and he shall be responsible for damages. Pwera na lang class kung talagang nakasaad no doon sa batas at naka-stipulate no sa kontrata ng dalawang parties na kahit pa merong fortuitous event mananagot ka pa rin debtor. So hindi pwedeng ma-extinguish class ang obligation kahit na wala yung bagay na yun kasi nakasaad sa batas at nakasaad sa or stipulated sa contract no ng dalawang parties. So the same rule applies when the nature of the obligation requires the assumption of risk. Okay? So kung yung mismong nature ng obligation ay hindi mo maiiwasan na makapagtamo no ng pinsala or risk no danger halimbawa na dapat i-shoulder ni debtor. So kung ano man ang mangyari doon class no magiging pananagutan pa rin siya ni debtor. So basahin ko sa Tagalog, ang isang obligasyon na binuos ng paghahatid ng isang tukoy na bagay ay dapat wakasan kung ito ay mawala o malipol nang walang pagkakasala ang may utang. At bago siya makapag-antala, kapag nasa batas o estipulasyon na ang obligor ang mananagot maging sa mga inaasahang pangyayari, ang pagkawala ng bagay ay hindi makakapagwakas ng obligasyon at siya ang mananagot sa mga pinsala. Ang parehong tuntunin ay mailalapat din kung ang likas na katangian ng obligasyon ay humihingi ng palagay ng panganib. So tandaan lang class na pagka nawala yung isang bagay, determinate thing, dahil sa fortuitous event at wala naman nakasaad sa batas at stipulasyon no, sa kontrata ng dalawang partido, so may extinguish sa obligation si debtor, no? Mapapalaya siya sa liability. Pero kung clearly stated sa batas at sa stipulation, no, ng parehong parties, mananagot pa rin class si debtor sakaling kahit na mawala yung bagay na yun dahil sa fortuitous event. Okay. So requisites to free the obligor from liability. So ano mga kailangan na present bago natin masabi na malaya ka na sa obligasyon. Okay? So una, obligation is a determinate thing. So dapat specific class. Next, loss without the fault of the debtor. Hindi niya kasalanan. Hindi kasalanan ni debtor. So ito ay dahil sa fortuitous event. Ano uli ang fortuitous event? These are events class that are beyond the control of the debtor. You may, it can be foreseen, no? Though it can be foreseen, pero hindi mo kayang pigilan. So, yun yung mga fortuitous event na sinasabi. Then, obligor is not in delay. Meaning to say, no, nawala yung bagay na yon, hindi pa naman talaga nakatakdang i-deliver. Halimbawa, bukas ang delivery, ngayon nawala. So, hindi pa delay si debtor. So, hindi niya magiging kasalanan. Napi-free siya sa obligation pagka ganon. And another consideration, dapat hindi bad faith, no, si debtor or si obligor sa pagkawala ng bagay na yon. Ibig sabihin, walang kapabayaan on his part. It's obligation to give a determinate thing. Obligor has an added obligation to take care of the thing with diligence of a good father of a family. Otherwise, he is negligent. So, inaasahan class sa atin, no, kapag nasa possession pa natin yung isang bagay, no, it is tawag dito, required, no, or it is expected from us to take good care of that thing. So, pag hindi mo inalagaan, magkakaroon ng negligence on your part. So, kailan naman, okay, masasabi na lost, no, yung determinate thing na yon. So, ito yung 5 instances. Kailan natin masasabi na, lost yung nangyari. Alright, number 1, the thing perishes. Nawala. Literal na nawala. Second, the thing goes out of commerce. The thing disappears in a way that its existence is unknown or cannot be recovered. There is theft or robbery. And lastly, it is impossible, no, to deliver the thing because the thing to be delivered belongs to another. So yung i-deliver mo sana ay, no, belong na pala sa iba, no? So note, if the loss is without the debtor's fault, he has the burden to prove his innocence. Class, pagka ikaw si debtor at hindi mo naman talaga kasalanan, bakit nawala yon? Ang mahirap lang sa part mo dito ay patunayan mo dapat na talagang hindi mo naging kasalanan yung pagkawala ng bagay na yon. At itong mga requisites dito ay talagang nasunod mo. Ano yon? Determinating yung obligation, hindi mo kasalanan, you are not in delay, no? And good faith ka sa paghawak ng bagay na yon. So, we mentioned about delay. Ano ba ang delay? So, debtor cannot deliver on due date. So, kung ngayon ang delivery at hindi niya nagawa yun, kinabukasan na, delayed na siya doon. So, if after delay, the thing is lost due to fortuitous event, debtor is liable. So, take note of this, class, ha? Pag before the delivery, nawala ang bagay dahil sa fortuitous event, extinguish obligation si debtor. But, kung delayed na yung debtor, hindi niya deliver on time, nasa possession pa niya yung bagay na yun, yung determinate thing na yun, at nawala, kahit pa dahil sa fortuitous event, hindi niya pwedeng maging alibi yun, class, at sabihin na hindi niya kasalanan. No. Kasi ang kinukonsider na natin dito ay yung time ng pag-deliver. Delayed ka na. Okay? So, effect of fortuitous event. So, fortuitous event does not necessarily extinguish the obligation to deliver a determinate thing. Hindi porket dahil nawala ang, hindi porket nawala rather ang bagay na yon dahil sa fortuitous event, ay agad-agad nating i-assume na extinguish na sa obligation. Remember, class, titingnan pa rin natin yung date of delivery, yung due date, kung delayed na siya or hindi pa. So, kung hindi pa siya delayed at nangyari itong pagkawala dahil sa fortuitous event, again, extinguish obligation. Pag delayed na, no, nawala yung bagay, kahit pa fortuitous event ang dahilan, liable si debtor. So it shall be extinguished when the determinate thing shall be lost or destroyed without the fault of the obligor or debtor and before he is in default. Okay, so yun ang sinasabi, class, dito sa Article 1262. Okay, so tingnan lang natin lagi kung ano yung dahilan at time na ba ng delivery or hindi. So no exemption from liability for the debtor. Hindi siya exempted, no? Hindi siya mapapawala sa kanyang liability kung una, when the law so provides. So kung talagang clearly stated sa batas. Pangalawa, when the stipulation so provides. So nakasaad doon sa agreement nila, sa contract nila na kahit pa may fortuitous event, no, ay mananagot ka pa rin debtor. Another one, when the nature of the obligation requires the assumption of risk. Wala kang choice debtor but to shoulder the risk. Kasi kasama talaga yun doon sa obligation mo. Then, when the obligation to deliver a specific thing arises from a crime. So, kaya ka nagkaroon ng obligasyon to deliver that specific thing is because you committed a crime. No? So, the general rule, the loss of the thing is borne by the owner. So, just in case, class, that the loss is not the debtor's fault, no? Then, the loss class will be shouldered, borne by the owner. Meaning to say, kung ano man yung nawala, ang mag-shoulder nun class ay si creditor or si owner mismo. Kasi hindi naman kasalanan ni debtor. So, how about when the loss is due to robbery or theft? So debtor bears the burden of proof. He must show that he could not resist rather the violence. So kung mayroong pagnanakaw, no, panluloob na naganap kaya nawala yung bagay na yon, oo nga, hindi kasalanan ni debtor but he needs to show proof that he is not he is not at fault, no? So kailangan magpatunay siya na talaga hindi na kayang pigilan yung krimen na yon. So debtor is liable for damages if he is negligent. So kung merong kapabayaan on his part, sa part ni debtor, no, magbabayad pa rin siya ng damages. Though hindi niya kasalanan na nanakaw yon, kaya lang kasi may kapabayaan. Okay? So magkaiba yun class, yung naging kasalanan niya, yung bigat ba ng parusa, magkaiba yun, no? Halimbawa, nilagay niya yung bagay na yon, no? He placed the thing within reach of thieves and not in secure or safe place. Nilagay-lagay lang niya yung gamit na yon doon sa labas, no? Madaming dumadaan na tao. So, syempre, no, maaari may matukso. Oh, nakawin yon. So, hindi niya inalagaan, hindi siya act as a good father of the family, no? So, negligent ang tawag doon. Negligence, no? So, negligent si debtor doon and magbabayad siya ng damages. So, effect on reciprocal obligation of the loss class. First, the extinguishment of obligation due to loss or impossibility of performance affects both the debtor and the creditor. So, the entire juridical relation is extinguished and the debtor must return to the creditor whatever he has received by reason of the obligation. So since extinguished na class ang obligation, kung ano man ang natanggap ni debtor mula kay creditor, kailangan niyang ibalik ito. So kung maalala niyo yung example natin before, si Pedro at si Juan, no, binalik ni Pedro ang paunang bayad ni Juan para sa kanyang palayan kasi hindi na fulfill yung condition. So same thing with this. Okay, let's move on to Article 1263. In an obligation to deliver a generic thing or tawag din natin doon ay undeterminate thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So, mawala man yan, ma-destroy man yan class, no, yung generic thing na yun, hindi ka pwedeng ma-extinguish sa obligation mo, debtor. Okay, yun ang ruling class. Pag generic thing yung i-deliver. Unlike pag determinate thing, specific thing, na pag nawala yun, no? Dahil sa fortuitous event, extinguish ka sa obligation. Dito sa 1263, hindi ganon ang sinasabi. Pag generic thing ang involved. Article 1264, the courts shall determine whether under the circumstances the partial loss of the object of the obligation is so important as to extinguish the obligation. So, korte class ang magtatakda kung yung nawala, kung yung nasira na yon ay ganun ba talaga kahalaga sa kabuuan ng bagay na yon para hindi na magamit or magamit pa yung tinutukoy natin na bagay. So depende sa sitwasyon, tutukuyin ng mga korte kung ang bahagiang pagkasira o pagkawala ng bagay ng obligasyon ay mahalaga para mapawalang bisa ang obligasyon. So korte class ang magtatakda nun. Ano ba ang effect ng partial loss, no? So there is partial loss when only a portion of the thing is lost or destroyed or when it suffers depreciation or deterioration. So again, when you speak of deterioration, this is the decrease in value. So partial loss is the equivalent of difficulty of performance in obligation to do under Article 1267. So there are some kinds of performance class, no, that it is really difficult, no, to perform. So as if this is equivalent to the so-called partial loss. So kung may kahirapan sa pag gawa ng isang obligasyon class, ituturing natin na ito ay equivalent ng partial loss. So in case of partial loss, once more, the court is given the discretion in case of disagreement between the parties to determine whether under the circumstances it is so important in relation to the whole as to extinguish the obligation. In other words, the court will decide whether the partial loss is such as to be equivalent to a complete or total loss. So for you to better understand this, let's have an example. Okay. Gloria obliged herself to deliver to Joseph a specific race horse. The horse met an accident as a result of which it suffered a broken leg. The injury is permanent. Here, partial loss is so important as to extinguish the obligation. So, bumili ng kabayo na pangarera si Joseph from Gloria pero na-involve sa accident yung kabayo at nabali ang kanyang paa. So dahil ito class ay pangarera, okay, at dahil wala nang magamit pa, syempre na paa yung kabayo dahil paano niya magagamit yung broken leg, may extinguish na yung obligation ni Gloria kasi that would render the horse ineffective na, no? Not functional na. Kasi paano ka mangarera kung broken leg? Okay? So, the injury is permanent, no? Kahit pa sabihin na isang paa lang ang nasira na nabali, no, whatsoever, no, ay extinguish na sa obligation si Gloria. Okay? So if the loss is due to the fault of Gloria, okay, kung halimbawa kasalanan talaga ni Gloria kaya na aksidente yung kabayo na yon, so she shall be obliged to pay the value of the horse with indemnity for damages. Doon sa unang class, dito, no, kung hindi niya kasalanan, napatunayan niya talaga na hindi niya kasalanan, no, ang magbe-bear, 'di ba, sabi natin kanina, ng loss ay si owner, si creditor. Pero kung kasalanan ni Gloria 'yon, okay, kailangan niyang bayaran yung halaga ng racehorse na 'yon plus damages. So, another instance class, if the horse to be delivered naman is to be slaughtered by Joseph, the injury is clearly not important. So kung yung kabayo na yun ay hindi naman pangarera, pangkatay lang halimbawa, okay, so hindi na mahalaga kahit broken leg pa yung i-deliver ni Gloria kay Joseph, okay? So pangkatay lang naman din kasi. So nasa discretion ng korte, pero obviously kahit hindi tayo ang korte, masasabi natin na that is not so important, no? Kasi kakatayin lang din. But no, even if there was fault on the part of Gloria, she can still deliver the horse with liability for damages, if any, suffered by Joseph. So, halimbawa, na-aksidente nga, no? Hindi naman kasalanan ni Gloria. So, pwede pa rin niya i-deliver yung kay Joseph, but, no, may but tayo dito, class. But, kung ano man ang may incur na damages naman ni Joseph sa pagkuha ng horse na yun, kasi nga, broken leg na, yun na lang ang pwedeng singilin niya kay Gloria. Halimbawa, since hindi na makapaglakad yung kabayo papunta dun sa slaughterhouse, so nag-arkela pa halimbawa si Joseph ng sasakyan para ikarga yun. So kung ano man yung magiging expenses halimbawa ni Joseph doon, no, ay pwede niyang singilin yun kay Gloria. So yun class ang effect ng partial loss, no, or partial na pagkasira ng isang bagay doon sa kabuuan ng bagay na yun. Kung yung ba ay magagamit pa or hindi na. So, let's move on to Article 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault unless there is proof to the contrary and without prejudice to the provisions of Article 1165. Pag nawala ang klase ang isang bagay na nasa possession pa ni debtor, No, we can assume that the loss is due to his negligence or fault talaga niya, kasalanan niya. Puwera na lang, except, no, merong patunay na hindi siya ang may kasalanan. So this presumption, ibig sabihin yung iniisip natin na siya ang may kasalanan, hindi ito class applicable kung ang pagkawala ng bagay sa possession ni debtor ay dahil sa mga natural calamities. Ano-ano yun? Pwedeng dahil sa earthquake, flood, storm, or iba pang klase ng kalamidad. So kapag ang bagay ay nawala sa mga kamay ng may utang, ito ay inaakalang nawala dulot ng kanyang pagkakamali. Maliban na lamang kung may makakapagpatunay sa taliwas nito nang hindi nakakapinsala sa probisyon ng Artikulo 1165. Ang sapantaang nabanggit ay hindi maaaring gamitin sa mga kaso ng lindol, baha, bagyo o anumang natural na kalamidad. So yun ang sinasabi dito, class, na pagka nawala sa possession ni debtor, ina-assume talaga natin na kasalanan niya yun. Puwera na lang kung may patunay na taliwas doon sa iniisip, pinipresume natin. So the article establishes a disputable presumption of fault whenever the thing to be delivered is lost in the possession of the debtor. This presumption is reasonable because the debtor who has the custody and care of the thing can easily explain the circumstances of the loss. The creditor has no duty to show that the debtor was at fault. Under the third paragraph of Article 1165, no, balikan natin doon sa mga previous lessons natin. Ano ba ang sinasabi doon sa third paragraph? The obligor who is not at fault, hindi niya kasalanan, na nawala yun, is still liable in case he is guilty of delay or has promised to deliver the same thing to two or more persons who do not have the same interest. So kahit pa nawala yan dahil sa natural calamity, no, or fortuitous event, no, mananagot pa rin siya kung delayed na siya at kung ipinangako niyang i-deliver yung same na bagay na yon sa dalawang magkaibang tao na may magkaibang interest. So in case of natural calamities, the presumption of fault does not apply. Tandaan natin, class, pag ang dahilan ng pagkawala, no, ng bagay na yon na nasa possession pa ni debtor ay dahil sa natural calamities, the presumption of fault does not apply. Lack of fault on the part of the debtor is more likely. So, it is unjust to presume negligence on his part. So, hindi makatarungan, class, na isipin natin na nawala yun dahil sa kapabayaan niya. That is beyond our control, class, yung mga natural calamities. So, illustration. Ben borrowed the car of Bon. On the due date of the obligation, Ben told Bon that the car was stolen and that he was not at fault. That is not enough to extinguish Ben's obligation. It is presumed that the loss was due to his fault. Hence, he is liable unless he proves the contrary. Nanghiram si Ben sa sasakyan ni Bon, sa araw na ibabalik na niya yon, nawala. So, hindi ganun kadaling sabihin na, Bon, sabi ni Ben, nawala yun, hindi ko naman kasalanan eh. So, i-assume talaga ni Bon, class, na kasalanan ni Ben dahil nasa possession niya nung nawala yung sasakyan. Unless, merong patunay si Ben na hindi niya talaga kasalanan dahil nawala yung sasakyan. Pero, unang-una, i-assume talaga ni Bon na kasalanan yun dahil nasa possession niya ng debtor, no? Nung nawala. So, number 2, suppose the house of Ben was destroyed because of earthquake. It is admitted that there was an earthquake and it was accidental and that the car was in the house at the same time it occurred. Here, Ben is not liable unless Bon proves fault on the part of Ben. So, nadamay lang yung sasakyan dahil sa earthquake. So, walang kasalanan si Ben. Pwera na lang kung meron uli, no, patunay si Bon na i-DDN si Ben, no, na may kasalanan doon sa nangyari. So, kung may negligence on the part of Ben, mananagot pa rin siya doon. Article 1266, the debtor in obligation to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. Ang nagkakautang sa obligasyong pagganap ay marapat din namang kawalan sa kanyang obligasyon kapag ang obligasyon ay naging legally or physically impossible ng walang kasiraan mula sa nagkakautang. So, papalayain natin sa liability class pagka imposible nang magganap pa yung pag-perform sa prestation. Maaaring dahil sa legal na aspeto or physically hindi na niya kayang gawin. So this article applies only to obligations to do. So ang applicable lang na prestation dito class is the prestation to do, not to give and not to do. Maliwanag, to do lang ang applicable dito sa 1266. So to extinguish the obligation, the prestation which the debtor is supposed to personally perform must have become impossible of performance after the execution of the contract. Otherwise, if the impossibility existed from the inception of the contract is void and logically, there will be no basis for the obligation to do. So, ito yung dalawang magkaibang sitwasyon class ha. Tandaan, pagka nagawa na yung kontrata, yung agreement, nakapag-usap na kayo kung ano yung mga kondisyones na dapat i-perform no, ng debtor, at biglang merong nailabas halimbawa na batas no or policy na contrary na kung contrary na doon sa napagkasunduan. So imposible mo nang matupad pa yung napagkasunduan kasi may lalabagin na siyang batas, no? So kung magkaganon class, no, extinguish na. O pwedeng complete extinguishment or partial extinguishment, no, ang mangyayari sa obligation ni debtor, no? Nagkasundo tayo pero biglang may inilabas na policy or batas, hindi ko na mape-perform yan kasi mananagot naman ako sa batas. So maaari mo na akong palayain dyan sa obligasyon ko or kung ano yung pwede pa under nung batas na yon. Yun na lang ang pwede kong din gawin, no? Pag physically naman class, no, hindi na niya kayang gawin, no? Kung yan ay paggawa, no, service o kung ano man, dahil physically wala na siyang gagamitin pa sa katawan niya para i-perform 'yon. Okay. So balikan natin yung sa contract. Paano naman kung habang binubuo nila yung contract, alam naman na nila talagang ito ay labag sa batas, no? Pero binuo pa rin nila. Halimbawa, alam naman nila na bawal ito, no? Pero nilagay pa rin nila sa stipulation na ikaw, kailangan mo magbigay sa akin ng ganito, which is bawal. So kung magkaganon class, ituturing natin na yung kontrata na binuo nila na yun ay void. Ano ba ang void contract? Umpisa pa lang, wala na yun visa. Okay? So ganon ang pag-interpret dito sa Article 1266. So po pwedeng after mabuo ang contract, merong lumabas na certain policy or habang binubuo pa lang yung contract, alam na nila within themselves na bawal ito pero tinuloy pa rin nila. So, magiging void ang contract. So, this article also contemplates on two kinds of impossibility. Legal impossibility, that is one, arises when the act stipulated to be performed is subsequently prohibited by law. So, halimbawa, Shakespeare agreed to construct a 32-story building for Hamlet. Before the construction could be started, a law was passed limiting the construction of structures in the area up to 10-story for purposes of safe aviation. The constructor is released from his obligation. So, ang una na pagkasunduan class, 32-story building. Okay. So, biglang may lumabas na batas na bawal na tayo ng more than 10 na story, hanggang 10 lang ang papayagan dahil para sa safety ng mga sasakyang mga lumilipad doon, ano? So, hindi ka na ngayon pwedeng tumuloy pa, no? Legal impossibility ang tawag doon. Kung itutuloy mo na magtayo ng 32, that would be against the law, no? So, partial extinguishment lang ang mangyayari dito class kasi hindi naman talaga natin totally in-extinguish ang obligation ni debtor pero hanggang 10 pwede niyang gawin. So na-extinguish na siya doon sa 11 pataas na obligation niya but still his obligation remains up to 10 story. Okay? So that is legal impossibility. Okay. Halimbawa din class sa mga gamot, di ba minsan once in a while may mga pinagbabawal na content ng gamot, ang BFAD o anong sakay man ng gobyerno yan. Halimbawa, ikaw, company A, tsaka yung pharmaceutical company, meron kayong kontrata na magsusupply ka sa company na yun ng ganitong gamot, no? Kaya lang, biglang may lumabas halimbawa na batas. So, hindi mo na matutupad pa yung kontrata mo kasi that is legally impossible na. Lalabag ka naman sa batas. So, si company, i-extinguish ka na niya sa obligation. So, kung bayad na yun class, no? Maaring mag-usap na lang kayo kung anong pwedeng gawin. Okay? Pwedeng ibalik ang bayad o iba na lang na gamot ang in replacement doon sa hindi na pwedeng gamot. So, nasa pag-uusap naman yan. Okay, number 2, physical impossibility arises when the act is supposed to be performed by the obligor due to reasons subsequent to the execution of the contract. Could not be physically performed by the obligor. Halimbawa, Da Vinci has agreed to paint the countenance of his client, Mona Lisa. So after the execution of the agreement, Da Vinci was involved in a car accident resulting in the amputation of his hands. The prestation has thus become physically impossible to perform. Subsequently, the painter, Da Vinci, released from his obligation to paint. So paano pa siya magpe-paint class, no? Nagkasundo sila ipipaint, no? Si Da Vinci at si Mona Lisa, nagkasundo sila. May kasunduan. Kaya lang, na-aksidente naman nito sa Da Vinci na nag-result sa pagkaputol ng kanyang kamay. So, wala na siyang pang-drawing, pang-paint. So, extinguish na sa obligation. So, yun yung dalawang kinds of impossibility class. The legal impossibility and the physical impossibility. Legal, paglabag sa batas. Physical impossibility naman, kung physically, parte ng katawan mo, hindi na makakagawa pa, makakapag-perform pa ng prestation. Article 1267, when the service has become so difficult to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. Effect of difficulty of performance. So, before I proceed with that, dito sa Article 1267, imposible nang ma-perform ni debtor yung prestation na yun class kasi napakahirap na, no? May mga at stake na, maaaring mapaminsala na, maaaring mapanganib na, kaya hindi na niya kayang gawin. So, ang tawag naman natin dito class is moral impossibility. So, effect of difficulty of performance, the general rule is that impossibility of performance releases the obligor. So, pagka impossible na mangyari, sabi natin, general rule, marirelease na sa obligation si obligor, either complete or partial. So, this is also preferred or referred rather as doctrine of the prestation of the commercial object or prestation of enterprise. This article refers to a moral impossibility or impracticability due to change of certain conditions. Note class that this article speaks of service. Service that is a personal obligation, not a real obligation, which is to give. Example, Victor, together with other construction workers, agreed to construct a road near a mountain. A hurricane caused landslide, making the construction of the road dangerous to human lives. So, in this case, Victor may be released in whole or in part from his obligation to continue with the construction. So, naatasan silang mag-construct ng road, kaya lang dahil sa natural calamity, nagkaroon ng landslide, at delikado na para sa kanila na ituloy pa yung trabaho. So, po pwede silang ma-extinguish obligation nila class, sila Victor, kasama ng 10 ng kanyang mga kasamahan class. Pwede sila ma-extinguish obligation, either lahatan, no? Lahat ng nakatakda nilang gawin, may extinguish sila doon, or partial lang. So kung ano lang yung area na sa tingin delikado, yun lang ang hindi mo na nila itutuloy. So in view of non-construction of the railroad, failure to grind sugar does not give rise to damages. So dahil hindi natuloy yung construction ng road, maraming businesses, halimbawa, ang apektado. So yung mga apektado na yun, hindi nila pwedeng isisi at ipataw yung damages na yun kay Victor kasi hindi naman nila kasalanan. Ang tawag uli natin dyan, class, ay moral impossibility. So, hindi mo pwedeng pilitin ang tao na gawin or tupdin pa yung performance na yun kasi magiging delikado na sa kanila. So, Article 1268, when the death of a certain thing undeterminate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price. whatever may be caused for the loss, unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. So, i-deliver mo yung isang determinate thing kasi nag-ugat yung obligasyon mo dahil sa krimen. So, mawala man yung bagay na yon, kahit pa sa fortuitous event, no, magbabayad ka pa din, no? So, the debtor offers a payment and the creditor refuses to receive it. So, anong pwede mong gawin? So, pwedeng i-consign ni debtor yung bagay na yon and thereby relieving himself from any responsibility for such thing. And number 2, to keep it in his possession with due diligence, subject to general rules of the obligation. So, example, Daniel stole Charity's watch. Daniel has the obligation to return it to Charity. So the obligation of Daniel arises from act punishable by law. So even if the watch is lost without the fault of Daniel, so after niya manakaw yon, nawala, hindi naman kasalanan ni Daniel. Still, he is liable for the payment of the price of the watch. So hindi naman mawawala yun, di ba? Common sense. Kung hindi mo naman ninakaw. So kahit na nawala yun sa possession ng may-ari, no? Eh wala kang pananagutan kasi hindi mo naman ninakaw eh. So the mere fact na in-install mo yun, no? May pananagutan ka. So the exemption to the rule is when is charity in mora accipiende. In either case, Daniel is liable if the loss is due to his fault. So mora accipiende or mora of the creditor is the delay of the obligee or creditor to accept the delivery of the thing which is the object of the obligation. So kung hindi muna tinanggap class ni creditor yung ino-offer na bagay ni debtor. So Article 1269, the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third person by reason of loss. So kapag pagkakatiwala ang napagkasunduan, ang nagpapautang ang may karapatang bumawi sa nangutang. Maaaring mawala sa kanyang karapatan sa anumang kagustuhan niya sa bagay na ito. Ang kanyang mga kasamahang nagpapautang, mga gumagarantiya at mga tagapanagot ay magiging malaya. Section 3 na tayo, condonation or remission. So when you say condonation, this is implied forgiveness. Pag sinabi namang remission, this is a release, pagpapalaya, no, sa utang or claim by will, no, kasulatan. So condonation and remission, it is a gratuitous abandonment of the creditor of his right against the debtor. So this is a form of donation in a negative form. So debtor is freed from obligation to make payment or delivery. So inalis na natin siya sa kanyang liability na magbayad o mag-deliver. So what are the kinds of remission o yung tinatawag na pagre-release sa utang? So it can be expressed or verbally or in writing or kaya naman implied, can be inferred from conduct. Hindi tahasang sinabi na pinapalaya ka na niya sa obligasyon pero yung kanyang kinikilos, yung kanyang ginagawa as if magsasabi na okay na yon, quits na yon. So another kind of remission is either complete or partial. So note class that express remission must be judicial in the form of a stipulation subject to court approval and must follow the formalities of donation. So hindi magiging valid ang donation class kung ang donation ay more than 5,000, dapat yan in writing and in public instrument. Okay? So Article 1270, what are the examples? So if condonation or remission involves real property or yung mga immovable property, it must be in public instrument, notaryado, notarized. A specification describing the property and its encumbrances kasama din doon, naka-stipulate. And accepted in public instrument. And that should be made known to the donor. So if condonation or remission involves personal property, no, ano-ano ba yung mga personal property? Halimbawa, sasakyan, jewelry. So may be done verbally upon the return or delivery of the thing. Or in writing with due acceptance in the case property exceeds 5,000. So hindi magiging valid class yung donation pag hindi in writing, no? Sa mga donation na nag-a-amount ng 5,000 pataas. So, kailangan in writing siya. So, Section 4, confusion or merger and merger of rights. So, the obligation is extinguished from the time the characters of creditor and debtor are merged in the same person. Debtor ka lang dati, eventually, no, nagkaroon ng complete turnaround, yung utang mo na yon, ikaw na rin ngayon ang creditor nun. So, nagkaroon ng merging. So, ang obligasyon ay walang bisa mula sa oras na ang anyo, rather ng may utang at nagpautang ay naging iisa sa isang tao. So, bakit na-extinguish ang obligation pag nagsama yung character ni debtor and creditor? Imaginein mo, class, ikaw ang nangutang, eventually, ikaw na ang maniningil sa sarili mo. Siyempre, quits na yun. Sarili mo yun eh. Extinguish na ang obligation. So, this is also one of the causes of extinguishment of obligation, yung confusion tsaka merger. Confusion or merger of rights is the meeting in one person of the qualities of the obligee and obligor with respect to the same obligation. So, the characters of the creditor and debtor are mixed in the same person. So, since it is nonsensical for the said person to push or pursue a claim against his own self, the merger results in the extinguishment of the obligation. So, na-extinguish, class, kasi ikaw na dati yung debtor, no, dumating pa sa point na ikaw na rin yung creditor. So, paano mo sisingilin yung sarili mo? No? Eh, ikaw na nga yung may utang, ikaw pa ang maniningil. So, confusion or merger, class, would result to extinguishment of obligation. So, yun ang sinasabi ng Section 4. So, okay. So, what do we mean by merger? So, it is the meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So, nagsanib sa isang tao ang character ni debtor and creditor. Pag sinabi naman guarantor, class, it is a person or an organization that promises to pay a debt owed by a second person if the latter fails to repay it. So, careful kayo, class, pag kinukuha kayo na guarantor kasi ang role nyo dito, pag hindi nakapagbayad ang totoong may utang, kayo ang hahabulin ni creditor. Section 5, last tayo, compensation. So, compensation shall take place when two persons in their own right are creditor and debtors of each other. Si A, debtor-creditor ni B, si B, debtor-creditor din ni A. So, nagkakaroon ng compensation, parang nagiging quits na, no? May utang ako sa iyo, may utang ka sa akin, so wala na lang tayong bayaran, i-quits na lang natin, i-compensate na lang natin sa isa't isa. So that is what we call compensation. Nagkabayaran kayo kasi pareho din naman kayong creditor-debtor sa isa't isa. So ang kabayaran ay mangyayari sa dalawang tao ayon sa kanilang mga karapatan kung sino nagpautang at sino ang umutang. Compensation is the extinguishment to the concurrent amount of the debts of two persons in their own right are debtors and creditors of each other. So we have 8 kinds of compensation: by its effect or extent, total, when both obligations are of the same amount. May debt to you, may utang ay 5,000, yours is 5,000 din, no? So same amount. Sa partial naman, 10,000 utang ko sa iyo, 5,000 lang utang mo sa akin. So partial 'yon. So mag-quits tayo sa 5,000 but I still need to pay you 5,000 more, no? Kasi hanggang 5,000 lang yung na-quits na compensate sa atin, so may kulang pa ako sa yung 5,000. So, fourth, by its cause or origin. Legal naman when it takes place by operation of law, even without the knowledge of the parties. Voluntary when it takes place by agreement of the parties. Judicial when it takes place by the order from a court of litigation. Facultative when it can be set up only by one of the parties. So example, Chow Queen owes McDonald 10 million. McDonald, on the other occasion, owed Chow Queen 15 million. So McDonald class is liable to Chow Queen with 5M. Kasi magpo-compensate sila up to 10 million, kaya lang, ang utang kasi ni McDonald kay Chow Queen 15. So may kulang pa si McDonald na 5M kay Chow Queen. So in order that compensation may be proper, it is necessary that each one rather of the obligors be bound principally, and that he be at the same time principal creditor of the other. Number two, that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind, and also of the same quality if the latter has been stated. Third, that the two debts be due. Fourth, that they be liquidated and demandable. And fifth, that over neither of them there be any retention or controversy commenced by third person and communicated in due time to the debtor. Okay, so that concludes our lesson for this morning.